Abusianfo yamamu nyina akwa abati bio edeba RAZ Media GH on YouTube. Abusia mesro se waba bomadre na subscribe to the channel. Abusia die ntie ne ye wo ha, die ntie wo ha enyina ne se agwa Bagbin rule na ode ma 4 parliamentarians ewo parliament se omu seat eye vacant no. Ene the Supreme Court edini ruling ababonten. Because you know say Afenyo Markins ede ruling na Bagbin ede Emma these 4 member of parliament na called Supreme Court we mu and a Supreme Court omo judge panyin na hono de abetra bonten say adentia Bagbin enimu say sabre we ya ye womunyi ye ntumi nkoye by election sabre we womi wo kase wo yi obi afri parliament at means say enye nipa na ho na wo na mom no oha ni constituency ena wo ha won sa anso na ebeye problem ama Ghana man no in terms of decisions making sa very important to the country ma ameno ni bufu yi ekura posanka say what kind of game are you people playing? How can it be possible say oman ewo ho na parliament enko ajuma? The Supreme Court judge maameno otukono na ni buafu yie papa na ne wa chirema chira Bagbin say you cannot take the laws into your hands. Abusha yenko ni yenko tie nsema the judge in the chair sitting there eka edichire Agwan Sumana Bagbin, the Speaker of Parliament. Yanko tie ba yebesan atoaso.
A person has been validly elected as a speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal. From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of parliament or a seat of a member of parliament has become vacant as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament that should be deemed by reason of the meaning of Article 97(1)(g) to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g). It has been argued by counsel for the Speaker that what the Speaker presented to Parliament on 17th October did not constitute a ruling that was executable or amenable to the controversy raised in the suit. On the contrary, the MPs cannot be representing people that they do not believe in, unquote, and the rights of their constituents to their representation. Thus, if a controversy is raised to the proprietary side with jurisdiction to provide a hearing to the plaintiff. According to the plaintiff, the Speaker's interpretation of Article 97(1)(g) was wrong because he, the plaintiff, also interpreted Article 97(1)(g) as affecting members of Parliament who wanted to change party affiliation. He also interpreted it as affecting the status of parliamentarians in the next Parliament and not while sitting in the 8th Parliament. These and others are the disputed interpretations that the plaintiff presented. For the sake of the record, we set out Article 97(1). A member of Parliament shall vacate his seat in Parliament upon a dissolution of Parliament, or if he is elected as Speaker of Parliament, or if he is absent without permission in writing of the Speaker and he is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet, or D, if he's expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution, or F, if he resigns from office as a member of Parliament by writing under his hand, addressed to the Speaker, or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member, or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2, notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitutional or political party forms part shall not affect the status of any member of Parliament. Now, clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex parte Zaneto Rollins, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election, take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself, of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. Exercise of discretion. The Speaker of Parliament is urging that the Supreme Court breach the rules of natural justice and rules prescribing the manner for exercising discretion in the orders made on 18th October 2024. In hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of the suit. It is a very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, the Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. The 4 constituencies of Amenfi Central, Fomena, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97 1G against Parliament. He was also doing so at a time that from the official records of Parliament present the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance arises of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with the of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024. The court carries the constitutional obligation of enforcement, if need be, by the scope of the orders made to stay enforcement of the Speaker's interpretation of Article 97(1)(g) on 10 days. The Speaker's Procedure Rules 2004 CI 40 for 10 days in the first instance if court was also enjoined to grant a submission that fails to appreciate the import of court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. Directions as it may consider appropriate. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly make orders that are appropriate for giving effect to provision. And the Constitution is so high crime for failure to obey such orders in article from obeying the orders of the Supreme Court. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election last few weeks to the 7th December elections without a clear determination of an early hearing. Others are bridging the 14 the parties to file their respectively thereafter. If the count urges an ex parte order ought to last by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked, or invoked from whether the jurisdiction exists. Both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused. So, Mr. So, Mr. Sorry, will you be filing anything, or should we hear?
The order was served on the Speaker on Monday, so he has 7 days. I will speak with him to draw his attention to the court's ruling, and then.
So it was served on him on the order was served on him on Monday.
That's Monday.
Monday was 29th?
No, last Monday is the 20th.
Monday, just around 2 weeks ago.
No, wait.
No,
on the 20th. It was served on the 20th.
On the 20th?
No,
and
21st. 21st. It was 21st.
So he's gone past the 7 days?
No, but if he's served with the order on that specific date, telling him to file within 7 days, it takes effect from the date of service. That is my understanding.
So he was supposed to file by 28th?
No, by the rules of the court, where the time limited for doing something is 7 days or less, weekends.
So he was supposed to file by when?
If you check out. Today.
Today?
Yes.
This suit is adjourned to Friday for completion. File your processes by close of day tomorrow. This is a constitutional crisis. We are living in a country where the parliament is not sitting. What is going on?
I'm not too sure that this suit is to enable parliament sit. It's to declare.
Very well. Yes, I take it. That's really in your
so
own
if I would
amendment.
plead that because look at the time that we are closing and the fact that we've done some work, filing it by Friday is not it's not possible. I also need to still go and take instructions, so maybe next week is fair. Today is Wednesday.
All right.
At least if I'll take 7 days to file the two.
No, do not count your 7 days from today. Your 7 days started running from 21st.
Lady,
you cannot make your own rules.
I'm just praying the court. I'm not making rules. I'm just praying the court.
So the date?
If he gives me instructions to file by Monday, the state raises a lot of constitutional issues. Let me properly assess the court if I'm instructed.
By the respectfully. Right. Yes, by the respectfully, there are 2 points that arise out of my left first, a brief submission to the court. And I made them. One, it is a matter for the interpretation of the Constitution. Respectfully, as I earlier on submitted, in a matter involving the interpretation of the Constitution, there's even no such party as a party who has an interest in the matter, apart from the entire state. Respectfully, it is not for nothing that the Constitution makes the Attorney General the defendant in all actions involving the government, an arm of which is Parliament. Especially my submission is that
and the Constitution. And the Constitution.
Yes.
In all constitutional actions, the Attorney General is required
to be the defendant.
Be a party.
Yes, to be a party. And especially, the point I make is that indeed the reluctance, with all respect, of the first defendant.
Can we get to know the objective?
Right. That first and foremost, if the first defendant is unwilling, with all respect, to file processes to enable the court to complete the case by Friday, my submission is that the first defendant is not even a proper party to the proceedings before the court. And his absence will not derogate from the court's ability to proceed with the hearing of the matter court. Indeed, it is even improper for the first defendant to have been joined to the action. The proper defendant should have been only the attorney general. The second submission I make is actually linked with the first. Especially if a party who is a public officer is joined to a constitutional action involving the attorney general. My submission is that even counsel for the first defendant has not been lawfully procured. He has no lawful mandate to represent the first defendant. The procurement of all goods, works, and services under in this republic must be in compliance with the Public Procurement Act. Section 14, subsection 1 requires the procurement of even the attorney general, with all respect, even the attorney general, when the attorney general is procuring service of a lawyer, the procurement goes through PPA approval. Even the attorney general, when procuring service of a lawyer to represent the country outside the Republic of Ghana, in a high court in, say, London or New York, will have to be subject to PPA approval. My reasonable submission is that the first defendant's counsel, I have tolerated him for not, and he's even seeking to use the fact that he doesn't have instructions of the speaker to continue as the excuse to delay proceedings. Whose failure to file proceedings should hold up the court. Number 2, counsel for the first defendant has no lawful mandate to represent the Speaker of Parliament, because the Speaker of Parliament is subject to the provisions of the PPA Act, and indeed he must have procured the service of the PPA. He must have procured the service of the first defendant's counsel by the prior approval of the Public Procurement Authority. And therefore, his representation of the first defendant is even unlawful, with all respect. The continuation of the constitutional crisis which the nation is subjected to. And my respectful submission is that the first defendant should either be struck out as a defendant, and then also his counsel cannot even represent him, because he doesn't have any lawful mandate to do so.
My Lord, with all due respect, it's not, because some of the matters are not even.
decisions on the substantive suit will be taken by the substantive panel, which will sit in the next few minutes. The court will rise.
All rise.
A member has become vacant or a person has been validly elected as a speaker, a person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal. From the above, it can be seen that if anyone raised the question